Urgent notice provided. Please take appropriate action. Final notice. Dear Dr. Rogers, between the date of December 6, 2021 and December 7, 2021, an employee of Communicare by the name of Rachel Alcorn came in receipt of inaccurate, untrue, and defamatory information given to her by Lafayette County Sheriff's Department, which she acknowledged had been sourced by the Lafayette County Sheriff Joey East himself. This in turn set off a series of events to follow, which in turn brought about irreparable injury while hindering the due course of justice, and as a result broadened the scope of all which currently transpires. In the interest of transparency into all of this, I'd like to make it known that this entire fiasco was created based upon the fact that for the second time in approximately 1 year's time, I had discovered an important record that was fraudulently altered in Lafayette County Circuit Court. Finding out how this record could have been changed and who could have been responsible for changing it was and still is two very important questions to me, as the same thing has happened now on both currently open filed matters of mine in Lafayette County Circuit Court. To make matters even worse, I've identified numerous pieces of inaccurate information reported by another employee of Communicare by the name of Stacy Waits, whom conducted the intake at the Lafayette County Detention Center on December 8, 2021. Then there's the absolute bizarre notation and reasoning by the doctor and nurse practitioner via remote video conference, which when combined with the other facts and all other erroneous and obnoxious matters at hand, lead me to believing that everything that transpired was the result of heavily politicized persecution for me having the drive and focus that I have on all current ongoing legal matters I am involved in. Particularly when this doctor notated on this report that I was very preoccupied with ongoing legal cases and described my condition as bipolar with delusions in his report, recommending inpatient commitment. To fault me for being preoccupied with ongoing legal cases is absolutely ludicrous when factoring in that I'm having to perform the work of an attorney due to not being able to afford the monumental cost an attorney would charge to represent me in 2 Supreme Court appeals, 2 Circuit Court matters, a Chancery Court matter, a recently wrapped up Justice Court matter, and at a bare minimum now 1 pending District Court matter. Being preoccupied with ongoing legal cases should be fully expected of anyone currently engaged in multiple legal battles in multiple venues such as I am, particularly when that individual happens to be representing himself and seeking full vindication from a complete miscarriage of justice that transpired in 2017, which continues to be exacerbated through continued lies tendered by Lafayette County officials and in particular Sheriff East, whom in fact played a hand in all that has occurred dating back to May of 2017. Contrary to the opinion of this doctor and your staff, whom never fact-checked anything, the claims I have made and produced a plethora of evidence supporting are not conspiracy theories or delusions, nor have I ever provoked anyone with my minor child, as the affidavit and reports following attested to. These are insinuations and character assassinations that Lafayette County, and in particular its sheriff, wanted to have conveyed, which at least temporarily it was successful in doing, through full exploitation of the state of Mississippi's mental health laws and through the assistance of your employees and contractors working on behalf of your organization, at the expense of my rights and liberties. The negligent acts of your employees have sought to demonize lawful, authorized, and constitutionally protected activity through pushing a narrative that was distasteful and untrue. I am an independent, credentialed member of the press, whom has taken on a role of investigating and reporting the corrupt acts demonstrated by this county while fully documenting my journey and seeking full vindication, and my credentials have been on file with the county and Sheriff's Department, so this was no new occurrence or surprise. For your convenience, I'm attaching a copy to this letter so that they again are on file in one more place in this county. The most unfortunate consequence, however, is that employees of Communicare, through not properly following policy and procedure as it relates to state and federal law, have now directly aided and provided assistance to certain Lafayette County officials, and in particular Sheriff East, in their attempt to cover up and abscond from their wrongful deeds. As a result of such, I've lost all trust in your organization and its staff. And honestly, who could blame me? The state of Mississippi's mental health laws are outdated, and I firmly believe that what has transpired here demonstrates the level of ease for the state and county governments to exploit their own system, and through doing so, have done a pristine job of exposing its major flaws in the process. The procedure for initiating civil commitment proceedings is detailed out in Mississippi Code 412165, in that it states, if any person is alleged to be in need of treatment, any relative of the person or any interested person may make an affidavit of that fact, and shall file the uniform civil commitment affidavit with the clerk of the Chancery Court of the county in which the person alleged is in need of treatment resides. But the chancellor or duly appointed special master may, in his or her discretion, hear the matter in the county in which the person may be found. The affidavit shall set forth the name and address the proposed patient's nearest relatives and whether the proposed patient resides or has visitation rights with any minor children. If known, the affidavit must contain factual descriptions of the proposed patient's recent behavior, including a description of the behavior where it occurred and over what period of time it occurred. If known, each factual allegation may be supported by observations of witnesses named in the affidavit. The requirements in this simply were not met. Nor were they ever justified. Not only was the affidavit not supported by any named witnesses, but the entire procedure was botched by the affiant attesting under sworn affidavit to non-factual claims, along with claims that were in fact constitutionally protected and ordained, particularly for an independent credentialed member of the press in the performance of his duties, which Lafayette County, through its officials, nor employees of Communicare had any right to interfere with and hinder further. The affidavit and reports to follow were comprised of judgmental and conclusory statements that were untrue in nature and relied primarily upon information stemming from an outside party whom was never named as required under the above statute. Fortunately, in one measure of good faith, there's a listed imposition of penalties against false affidavits being filed in bad faith for a malicious purpose, in that the prohibition against charging the affiant other fees, expenses, or costs shall not preclude the imposition of monetary criminal penalties under Section 4121-107 or any other criminal statute, or the imposition of the chancellor of monetary penalties for contempt if the affiant is found to have filed an intentionally false affidavit or filed the affidavit in bad faith for a malicious purpose. A state law cannot be held constitutional if it directly infringes on established law on a federal level, to include if that particular law/legislation deprives a citizen of any constitutional right or any guaranteed due process right, to include substantive, in that a citizen is subjected to the undue deprivation of life, liberty, or property. A finding of mental illness alone cannot justify a state's locking a person up against his will and keeping him indefinitely in simple custodial confinement. Assuming that term can be given a reasonably precise content and that the mentally ill can be identified with reasonable accuracy, there is still no constitutional basis for confining such persons involuntarily if they are dangerous to no one and can live safely in freedom. The matter at hand was decided upon in Davidson v. O'Connor, a landmark U.S. Supreme Court case, which stated in short, a state cannot constitutionally confine without more a non-dangerous individual who is capable of surviving safely in freedom by himself or with the help of willing and responsible family members or friends. The question was then posed, may the state fence in the harmless mentally ill solely to save its citizens from exposure to those whose ways are different? One might ask if the state, to avoid public unease, could incarcerate all who are physically unattractive or socially eccentric. Mere public intolerance or animosity cannot constitutionally justify the deprivation of a person's physical liberty. See Cohen v. California, 403 U.S. 1524-26. In conclusion, the flaws which have occurred in this matter have not only violated the mental health laws of the state of Mississippi, but have created a material breach of substantive due process rights guaranteed to all citizens and protected under federal law. As such, you are hereby requested to review and revise your current policies within the following 7 days in order to bring them into compliance with not only state law but federal law, in order to circumvent a similar matter from occurring in the future, and to provide in writing any offered changes to such policies. In addition, as stated above, please take appropriate action to produce and preserve any and all information associated with the incident below, to include any information describing the incident below that is maintained by Communicare and or any of its employees, to include any individual subcontracted out. This preservation should also include all audio recordings taken during intake, documentation notes taken, any communication regarding the matter sent and or received leading up to including the final determination being made to involuntarily commit Matthew Reardon to a state hospital facility on December 9, 2021. My best regards, Matthew Reardon.